Good morning, members. I'm proud to be here today to present Senate Bill 188, the Crown Act, which stands for to create a respectful and open workplace for natural hair. Eurocentric standards
Thank you.
of
We have a
beauty
motion
have
and a
long
second.
held the underpinnings of American culture since the founding of our society, determining what was acceptable and attractive in the media, in academic settings, and at work. For centuries, black men and women didn't often challenge those standards. We straightened our hair with heat or chemical relaxers to meet those Eurocentric standards. Until 2016, a Google image search for the term unprofessional hairstyles yielded only pictures of black women with natural hair or wearing braids or twists. Although disheartening, the fact was not particularly surprising. And so, members, the purpose of this measure is twofold. First, it's clear there's a great need to educate the general public about the unique qualities of black hair texture and how they relate to the opportunity to wear natural hairstyles, as well as the experiences of black people. Secondly, it's due time to challenge the commonly held myths and misconceptions about what determines professional hair in the workplace, in schools, and even the military. For years, there have been too many cases of black employees and applicants denied employment or promotion and even terminated because of the way they chose to wear their hair. Students sent home from schools based on policies that discriminate against young black girls and boys whose parents have chosen to lock their hair or braid their hair. We're talking about groomed hairstyles like my locks, which would, without question, fit an image of professionalism if bias or negative stereotypes were not involved. Specifically, SB 188 protects this right by clarifying in the Fair Employment and Housing Act and in the Education Code that the definition of race is inclusive of traits historically associated with race, i.e. hair texture, including but not limited to hair texture and natural or protective hairstyles. This bill does not supersede health and safety code regulations or prevent employers from enforcing reasonable grooming standards that relate to a bona fide job qualification. The Crown Act has enjoyed bipartisan support and has received no votes. With me here today, I'm proud to have Wendy Green, who's a visiting professor at Washington and Lee University School of Law, where she serves as the Francis Lewis Scholar in Residence. Ms. Green is the leading expert on hair discrimination cases and was quoted in the EEOC versus CMS court opinion. Also with us here today is Akilah Hatchetfall, who is a licensed cosmetologist and a loctician. She owns a salon here in Sacramento called Sacred Crown Salon. They will, Ms. Hatchetfall will speak on the intricacies and process of natural hairstyles if you have questions. I would ask for your aye vote.
Thank you. First witness, please.
Okay, good morning, Chair and members. My name is Wendy Green, and as the Senator pointed out, I am a leading anti-discrimination law professor and advocate. I graduated from Xavier University of Louisiana in New Orleans with honors in English and a double minor in African American Studies and Spanish. I also earned my Juris Doctorate from Tulane University School of Law, also in New Orleans, and a Master's of Law from the George Washington University School of Law, where I specialized in comparative slavery and race relations law, as well as employment discrimination law. My legal publications have been instrumental in creating civil rights protections against discrimination in workplaces, public accommodations, and in schools, including the New York City Commission on Human Rights Enforcement Guidance, which clarifies, like the Crown Act, natural hair discrimination constitutes unlawful race discrimination. Accordingly, I've spent much of my professional career as a legal academic increasing awareness around the harms of unchecked discriminatory grooming policies, naming policies that denigrate natural hairstyles as extreme, excessive, distracting, and unkempt. Policies that require African descendants to cut off their hair simply because the way it naturally grows out of their heads. Or in the case of African descendant women and girls, grooming policies that require that they don straight hair, usually achieved through toxic chemicals, extreme heat styling, wigs and weaves, which are expensive and time-consuming to maintain. They too often result in painful chemical burns, hair and scalp damage, as well as hair loss. Research also indicates potential correlations between hair straightening products that Black women frequently use, and their increased chances of developing uterine fibroids, hormone-related infertility, and more aggressive forms of breast and uterine cancer. Similarly, studies indicate a possible linkage between chemical relaxants and increased hormonal activity amongst African-descended girls. Therefore, natural hair bans leave African-descended women and girls in a precarious catch-22. Either don your natural hair at the risk of lawfully being deprived an employment and or educational opportunity, or don straight hair at the risk of enduring consequential harms to your psychological, physical, and emotional well-being. My scholarship and advocacy have critiqued federal court decisions which sanction this catch-22 by failing to treat natural hair bans as race discrimination. This state of affairs is largely due to an outdated judicially created rule known as the immutability doctrine, which I can discuss in Q&A if needed. But most notably, federal court's strict application of the immutability doctrine has produced hair-splitting distinctions. If, for example, an employer denies an African descendant a job because she adorns an afro, the employer engages in unlawful race discrimination. However, the moment she twists, locks, or braids that afro, her hair, and suffers adverse treatment on these grounds, the employer's discrimination is deemed lawful. The Crown Act fills this unjustifiable gap in statutory protection for workers and students who suffer natural hair discrimination, a systemic form of racial discrimination that harkens back to eras of racial slavery and racial apartheid in this country. Based upon California's unique role as a national leader in advancing equal opportunity for all, there truly is no better state to not only have this timely dialogue on natural hair discrimination in workplaces and schools, but also take meaningful action toward correcting this inequality under the law.
Thank you. Hair-splitting decisions.
Thank you.
Y'all got the pun. That's
You
good.
could use it.
And you didn't even cry. You did that smoothly. Lovely. Next.
I only bring the best before your
Absolutely. Absolutely.
Don't get it
If you could only bring some examples of unprofessional hairstyles that we could see, could you bring some examples of unprofessional hairstyles?
No, that's not my job to do. I would only bring before you professional examples.
Okay, so I noticed. Please.
Hi, good morning to the Assembly members. My name is Akila Uwimana Hatchett Fall, and I am a cosmetologist and also a person who's done natural hair for 32 years. I also have a background in Pan-African studies, and I've served a community in our community as a community activist also, and have over 300 clients. So one of the things that I'd like to add is also that from the beginning, before colonization, before we even came to this country, African people have always had their hair as a crown of glory, as a point of just knowing who they are. It has not just ever been a hairstyle for us. It's always denoted things like our tribe or our clan. It's denoted our marital status, our economic status. It denotes everything for us. It truly is the first thing that you look at. You can tell where a person is at when they look at their hair. So to have to subscribe and be marginalized to Eurocentric white supremacist standards of beauty is not only like Sister Wendy said, is not just harmful to us psychologically, physically, mentally, but it also is just a dampening of your spirit to not be able to put 100% forth of who you are as a person. And always have to be worried about who you are and what you look like is just not something that we should ever have to be subjected to, although we have been for 400 years. So I ask that you also pass this bill, because it is important for us to be able to, each of us, put forth our best effort as who we are. And as African people, our crown of glory is our crown of glory, and we deserve to be able to be who we are. Thank you.
Thank you. Others in support, if you could give us your name and your affiliation, please.
Mr. Chair and members, Leanne Tratton, representing Black Women for Wellness, and strong support.
Good morning, Teresa Taylor Carroll. I'm a member of Alpha Kappa Alpha Sorority Incorporated. Nationally and statewide, we consist of thousands of members with many different hairstyles, and we are in strong support of this bill.
Leah Barrows on behalf of the Crown Coalition. The Crown Coalition is a national alliance that is comprised of Western Center on Law and Poverty, Urban League, Color of Change, and Dove. This coalition was convened to address anti-discrimination legislation across the country. We are proud to co-sponsor SB 188 today and respectfully ask for your aye vote. Thank you.
Thank you.
Mariko Yoshihara on behalf of the California Employment Lawyers Association and strong support.
Pamela Gibbs, representing the Los Angeles County Office of Education, and we strongly support this bill on behalf of California's children. Thank you.
Amanda Dworkin on behalf of the American Civil Liberties Union of California and strong support. Courtney McKinney with Western Center on Law and Poverty and strong support. Thank you.
Good morning, Mandy Lee on behalf of Personal Care Products Council in support.
Christopher Sanchez with Trailer and strong support.
Priscilla Quiroz on behalf of City and County of San Francisco in support.
Valerie Williams on behalf of the California Urban Partnership in strong support.
Rebecca Gonzalez, National Association of Social Workers, California chapter in support.
Puneet Puriwal on behalf of Equality California in support.
Good morning, Seth Bramble here, rising on behalf of more than 300,000 educators in California, the members of the California Teachers Association in strong support.
Thank you. Anyone else in support? Seeing none, is there opposition? All right, seeing none, I'll bring it back to the committee. Mr. Colera?
Senator, I just want to thank you. I really like this bill, and I think it's very important. Bill and Professor, thank you for taking the time to be here with us and illuminating us both on the legal as well as historical importance of this bill. And one thing I'd heard it was making its way through the Senate, and I didn't realize until I was preparing for the hearing this morning that it was also amending the education code, which is so critical because, as we all know, the internalized, self-imposed negative thoughts of oneself start at a very young age, and the fact that this is going to impact in a positive way many thousands of young people in the state and make them be proud of who they are, I think will really set them on a positive path. And so very much in support of this bill, and thank you.
I appreciate that, Mr. Colera. If I just might add, there's a school board member right here in Sacramento who has a daughter who has experienced bullying because of her mother's choice to allow her to wear her hair natural. She's very young, 6 or 7 years old. And her mother brought her to the Capitol to meet me to see a professional woman who, for all of my elected life, has chosen to wear my hair in its natural state. And so we hope that through this bill, not only will we change the law, but through the press and through women coming forward to talk about our experiences, also setting an example for both mothers trying to make difficult choices on behalf of their little girls. Everyone also saw in December of last year the video of the young wrestler who was violently assaulted by an official and told either cut your locks or let your team down and not wrestle. That was midway through that wrestling tournament, and he'd been a high school wrestler for his entire high school experience. And so we hope to prevent actions like that from taking place, at least here in the state of California, ever again.
Well, thank you for being a very positive role model for hundreds of thousands of Californians.
Appreciate you.
All right. Anyone else? Senator, you may close.
I would just say, colleagues, that it's 2019, and from my perspective, any law that sanctions a job description that immediately excludes me from a position, not because of my capabilities or experience, but because of how I choose to wear my hair, is long overdue for reform. With that, I respectfully ask for your aye vote on the Crown Act, Senate Bill 188.
Thank you. We do have a motion and a second. Motion is due pass 2 appropriations. Call the roll, please.
Stone?
Aye.
Stone, aye. Gallagher? Chow? Chow, aye. Chu? Gonzalez? Gonzalez, aye. Holden? Holden, aye. Colra? Colra, aye. Fong? Fong, aye. Mainshine? Mainshine, aye. Petrie Norris? Petrie Norris, aye. Reyes? Reyes, aye.
Thank you. That bill is out.
Thank you very much, committee members, for your attention.